Hello, my name is Chris Johnson. I'm a business lawyer and entrepreneur. I am the founder of Johnson Law, but prior to that, I founded my own business, and I still currently have other businesses outside the law. And a lot of my clients are entrepreneurs like perhaps yourselves. I've oftentimes heard from them or other business people out there the phrase boilerplate and referring to certain provisions as a contract as just boilerplate, as if that's just standard and it can't be changed. And even though they say that, I've found that these business people don't really understand what those provisions mean. Now, there's something in the law, there's a phrase called ignorance of the law is no excuse. And what that means is it doesn't matter that you don't know what something in a contract means. You are charged with knowing what it means. You could find out what it means. You can hire an attorney to advise you what it means. You can't walk into court and tell the judge, well, I didn't understand it said that. It doesn't matter. That's not a defense. No one's going to hear that. It's not acceptable. So what I'd like to do with you today is go through some common contractual provisions and just tell you what the heck they actually mean. What I'm not going to cover today are the scope of products or services being bought or sold, purchase price, payment terms, things like that. I view those more as commercial terms, not legal terms. However, they are extremely important. And after the business people come up with the commercial terms, it's oftentimes very important to have the attorney review the way it's described, the language that's used to make sure there's no ambiguity or vagueness in what's actually being provided, the scope or the payment terms, things like that, because oftentimes disputes do arise over those types of things if the language is not clear. Merger clause, you may have heard this before. I have an example here. It says this is the entire agreement between you and the company, and it supersedes all prior agreements, understandings, statements, representations, negotiations, or discussions between you and the company or any of its agents, employees, or representatives. This is the merger clause. And what this means is this is the final agreement. We're only going to look at the four corners of the agreement if there's a dispute. Doesn't matter what you guys talked about before. It doesn't matter what other text messages you have between each other. I love when clients come to me and they're like, I've got a whole string of text messages, this and that. That could show intent of the parties, but intent doesn't matter unless there's some language in the contract that's unclear, that's ambiguous. Other than that, this merger clause protects the integrity of the words on that piece of paper and says the judge is not going to look at anything else. Now, there is an exception to this, and that is fraud. If there's some kind of fraud outside the contract, then that could be examined by the court. Arbitration provision. An example I included is any dispute arising out of or relating to this agreement shall be subject to final binding arbitration. The arbitration shall be administered by the American Arbitration Association and shall take place within a 50-mile radius of the company's principal place of business or at such other venue selected by the company and its sole and exclusive discretion before a single neutral arbitrator. Arbitration and arbitration provisions, that's a whole other presentation, so I'm going to keep this really simple, and I'm going to talk about the pros and cons of arbitration. I typically do not like arbitration. For me personally, I only like arbitration if confidentiality is an extreme concern. If I don't want other customers of my client finding out about a potential dispute, then arbitration is an effective tool to keep the proceeding itself confidential. However, arbitration is expensive. And here in this provision, there's a single arbitrator. Sometimes there's a panel of arbitrators. It depends how this arbitration provision is written, but it can get expensive. And the arbitrator bills like an attorney. So you're going to see very common $30, $40, $50, $60,000 bill from the arbitration on top of paying your attorney. Whereas the court system, the judges are provided for free. And arbitration, in theory, was supposed to be cheaper, more streamlined, faster. I think in practice, it's very similar to the judicial system and the amount of time that it takes for a proceeding to take place and the amount of discovery that's conducted and the costs with it. Plus, I don't like that arbitration decisions can be arbitrary. Yes, oftentimes the arbitrator is a former judge, but they have more leeway as an arbitrator. They don't have to follow the letter of the law to a T. They can fall on equity, fairness, more perhaps than a judge in the judicial system. So for these reasons, I tend to err on the side of not wanting arbitration, especially if I feel like if there's a dispute, I want my client to have the option of telling their story to a jury. Limitation of liability. This is a very important provision in a contract, and it can be diced a number of different ways. So this limitation of liability provision says, under no circumstance shall the company be liable to you for any indirect, exemplary, punitive, incidental, or consequential damages, including damages resulting from loss of use, loss of profits, interruption, or loss of business, lost goodwill, lost revenue, and lost opportunity, and any and all liability the company has or may have to you is limited to the amounts received by the company under this agreement. Wow, it's a lot. Let me break this down a little bit. First of all, there's a limitation of consequential and punitive damages. What are consequential damages? Well, they're oftentimes very important. They're oftentimes larger than the actual damages. The actual damages are the damages related to the contract itself. Consequential damages are things or ways in which you were harmed resulting from the breach of the contract. One of the most common consequential damages is lost profits. So for instance, if an IT person breaches the contract by failing to do a good job at preventing a security hack, and then the security hack occurs, if the security hack occurs, it's way more probably than, let's say, the damages are way more than perhaps the $20,000 that the IT person charged for security measures. It could be millions of dollars in damages resulting to the company because of the hack, and that those are consequential damages, lost profits that resulted from this breach. So getting rid of consequential damages is really good for a party that wants to keep their potential liability lower. For the other party, they want consequential damages, at least the option of it, because it gives them leverage moving forward in a case if they have a really big case to start with. Another part of this provision is that it caps the liability to the amounts received by the company under the agreement. So in the instance of the IT, that person was paid $20,000, absolute cap of $20,000. That's really attractive to the IT person because they're just looking at a maximum of a $20,000 case. That's great for them. It's a disincentive to the other side because they're likely not going to file a case over $20,000 because you can easily eat up $20,000 in attorney's fees. There's different ways to do the caps. It doesn't have to be the amount received on the contract. It could be like a hard cap of $500,000 or $1 million or something like that. All that's negotiable, and that's why I'm saying these are not boilerplate provisions. They really can be tailored and used in different ways, and you need to understand how they can be used in different ways and work with your attorney in doing this effectively to protect your interests. Disclaimer of warranties. All services, deliverables, and work product that are provided by the company are offered on an as-is, where-is, and with all faults basis, and the company makes no warranty or representation, oral, written, express, implied, statutory, or otherwise, with respect thereto, including without limitation, their quality, performance, merchantability, or fitness for a particular purpose. I see these a fair amount, unfortunately, in service contracts, which they're probably the person that wrote the service contract, they're just going online and copying and pasting. They're like, oh yeah, as is, where is. That one looks really good. Let's include that in the contract. I would be more careful if I were the company in having this provision in my contract, because if you're disclaiming all warranties, what are you really agreeing to do? If you're not even agreeing to do work in a workmanlike manner, standard in the industry, then you're agreeing to nothing. And if I were looking at that contract from the consumer side, negotiating it, I would absolutely strike that provision, and it would look like the company's doing something in bad faith. This provision right here can definitely be more narrowly tailored. So you would use a scalpel and not a hatchet to deal and limit with your warranties being provided to a customer. Indemnification. These can get complicated, but indemnification essentially is an insurance policy related to third-party claims. I really don't like giving indemnification because it creates potentially unlimited liability. And let me explain that a little bit. First, let's read the provision. You agree to indemnify, hold harmless, and defend the company and its officers, employees, agents, and contractors from and against any and all liability, loss, damage, claims, causes of action, and expenses, including reasonable attorney's fees, caused or asserted to have been caused, directly or indirectly, by or as a result of the company's breach of this agreement or the services rendered by the company. So you need to look first at the scope. So if the company breaches the agreement or does something with respect to the services, and there's a third party claim, then the indemnification is triggered, but to what extent? I mean, if damages are millions of dollars, this says that you're liable to us for millions of dollars. So just like the limitation of liability, you can put caps, limitations on this, or just get rid of the indemnification altogether, or limit the scope of the indemnification to gross negligence, intentional misconduct. Right now, it's just like if anything happens, not if there's a bad act or I make a mistake. So these can be carefully carved and limited, and they're really tricky, and they're certainly not boilerplate. Force majeure. These oftentimes were copy and pasted in miscellaneous provisions and not even touched. Before COVID, I'll admit I was somewhat guilty. And then COVID happened, and people really scrutinized these provisions to see if it covered something like a pandemic, epidemic, COVID. This language that I pulled says neither party will be liable to the other for failure to perform any of the services required herein in the event of strikes, lockouts, calamities, acts of God, unavailability of supplies, or other events over which the parties exercise no control for so long as such event continues for a reasonable period of time thereafter. So this provision doesn't mention pandemic, epidemic, anything like that. Under a lot of court cases, the acts of God, things like that, does not cover the epidemic, pandemic. You should have specifically stated it if you wanted it to cover it. So this would not excuse a party from performance even under COVID. What about escalating prices and the supply chain? That was a major issue out of COVID. Again, this one wasn't addressed. If you're a manufacturer and you are buying goods and compiling them, and you might be buying things from China, and because of problems in the supply chain, the prices became incredibly more expensive or delayed by maybe 2 years, and you're fulfilling major contracts, you want to think about those things and you want to bake them into your contracts so you can be excused from performing under the contract if something like that happens. We saw that in the builder space. We saw it in a lot of spaces. And unfortunately, the boilerplate force majeure was used and people weren't really drilling down on what are the risks that could happen to my business that would impact my ability to perform under this contract. Venue and choice of law. The provision I pulled says this agreement shall be governed by the laws of the state of Texas. Any lawsuit, action, or proceeding arising out of this agreement shall be instituted solely and exclusively in the state district courts of Dallas County, Texas. So the choice of law is that state of Texas applies. So why is that important? Well, choice of law, you may have counsel in a certain state and they're more familiar with laws in a certain state. It might be your home state. You're more familiar with laws in that state. That would be a good reason. The venue provision is that it should be filed only in the district courts of Dallas County. So why does this matter again? You might be located in Dallas. Your customer or the other party might be located in New York. For a company or someone else located in New York to file a case in Dallas is a lot harder. They have to go hire an attorney they're not used to, hire local counsel, et cetera, et cetera. The cost of being in that venue. So it's better generally to pick a venue where your company is located or a venue where you're comfortable with the court system and comfortable in getting consistent and fair rulings, because not all judicial districts are like that. Next, I'm going to address term, termination, and renewal. This provision says the company agrees to endeavor to provide you 60 days notice prior to terminating your employment, provided that failure to comply with such notice shall not constitute a breach of this agreement. You agree to give the company 60 days notice prior to terminating your employment, and failure to comply with such notice requirements constitutes breach of the agreement. The term will automatically renew for successive periods of 1 year each, unless either party terminates the employment period in accordance with this agreement. So really just be careful of notice requirements and contracts. They're often forgotten. For that reason, I'm not really a fan of agreeing to a notice requirement for my contract. If it's the other side, however, I'll put a notice provision in knowing that they might even forget to comply. Be careful of auto renewals too, which are oftentimes tied in with these notice provisions. I had a case worth multiple millions of dollars because one of the parties blew the notice deadline and actually terminated the contract after the notice period had actually already expired, and they were forced into another term under the contract, and the whole fight was over that, and it was worth millions of dollars. It happens quite frequently, and for that reason, you just really got to be careful of these automatic renewals and notice provisions, and read them and negotiate them and understand them and keep track of them. Non-disparagement. You will not make false, disparaging, demeaning, or inappropriate statements concerning the company, its affiliates, or any of their employees, services, or clients, or make any statement that is intended to adversely affect the impact or the company or its affiliates. What does that really mean? False, disparaging, demeaning statement. Who determines whether something's false, demeaning, or disparaging? In today's day and age, with electronic communication, social media, things like that, something could be said, or there could be a game of telephone where it's not quite clear, or maybe it's misunderstood or misinterpreted whether someone actually said something that was harmful to the other person. I typically will not agree to a provision like this unless it's within a settlement agreement and it's mutual to both sides. And again, that depends on who I actually represent in the transaction. But the non-disparagement, it seems innocuous, but this is something that can be abused by the other party, and it's something to be carefully considered and crafted. So I've covered some basic provisions, and I hope that was helpful. I hope that you can see that the language here is really important in these provisions, that it can be changed in different ways, and it can be changed in ways to help one party or another, which is why it's really important to have an attorney that can just focus on your interests, because they can craft language that can protect you from the other side. If they're doing a middle of the road contract, or if it's something pulled offline, yeah, it's going to be more boilerplate and it's not really going to help anyone and it's not going to accomplish anything. And you might be in a situation where some issues litigated later and it costs you a lot more on the back end than it would have on the front end to use an attorney. If you want to talk to me about contracts, our firm is a business firm. That's what they do. They represent businesses, do contracts all the time. You can schedule a consultation with me at calendly.com/Chris Johnson. Johnson spelled Johnsen. Thank you.